All right, we can be seated. Your next witness?
Thank you, Your Honor. The people call Amber Harrison.
All right. Come on up, Ms. Harrison, up to the witness stand, please. Raise your right hand. Excuse me. Do you solemnly swear or affirm under penalty of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Have a seat.
Good morning, Ms. Harrison.
Morning.
Could you please start by introducing yourself to the jury by your full name?
Amber Michelle Harrison,
And how do you spell your last name for the court reporter?
Harrison.
Ms. Harrison, where are you from?
Right now I'm living in Biloxi, Mississippi.
Where are you originally from?
From Colorado and California.
Okay. Was there a period of time that you lived in the Durango area?
So yes, I did, from 2006 to 2020.
Okay. And what did you do for work in the time that you were here in the Durango area?
I was an attorney and a judge.
And what years were you an attorney and what years were you a judge?
2006, I'm still a licensed attorney in the state of Colorado, and I was a judge from 2016 to 2020.
Okay. And what do you do in Mississippi now?
I work at a spa as a concierge.
Is that a little more relaxing than being an attorney?
Very much so.
Where'd you go to law school?
I went to law school at Thomas Jefferson School of Law in San Diego, California.
And what was your focus in law when you were a practicing attorney?
My whole career in the legal industry from 1996 forward is family law, domestic.
So you said you came to the Durango area around 2006. When did you know the Redwine family?
I met Ms. Hall in 2008.
In what context did you meet Ms. Hall?
She was assigned to me by my my firm as a client.
In what type of litigation?
Divorce.
At the time, what was going on with the case at the time, just generally speaking?
She and Mr. Redwine had obtained a legal separation through another attorney previous to my involvement. So at that time, it was my job to help her get a dissolution of marriage and divide the remaining marital assets that had not been divided in the legal separation.
Breaking that down, is that basically dividing a property?
Yes, property, debts.
Setting that aside, what was the custody situation at the time that you met Ms. Hall?
At the beginning of the case, the parties stipulated to parental responsibilities for Dylan as 50-50. The parties were going to share equally.
When you say at the start of the case, what time frame are you referring to?
2008, probably one of the first hearings, if not the second hearing we went to.
Okay. And then did you handle the formal divorce in 2009 as well?
Yes, I did.
And then did you stay on representing Ms. Hall through a custody case as well?
Yes, I did. Still the attorney of record on that case.
So going through the split custody years, were those split custody years where Dylan was going to both houses equally, or what was it really?
No, in the beginning, I think he was, Mr. Redwine was exercising his parenting time somewhat. It became less and less over the years to the point that he was not exercising parenting time, requiring Ms. Hall to take Dylan with her when she had to travel for work and would miss school.
And was this in the time frame prior to the formal divorce or after the formal divorce?
After the formal divorce. So when the decree was issued in 2009, this was after.
And then was this before or after the custody was actually an issue in the case.
Okay, I don't understand the question.
Yes, let me ask a different question. Was there a point in time when there was a motion to relocate?
Yes,
And the time frame, was that July of 2012?
yes, sir.
So between 2009 and 2012, is that the time frame you're talking about right now?
Correct.
Let's fast forward to that September of 2012. Were you involved in that litigation itself?
Yes, I was.
Did the motion to relocate, what was that?
It was a request by Ms. Hall to relocate with Dylan to,
Your Honor, this is hearsay. I mean, to have the lawyer discussing what client requested and say that,
Isn't she discussing what the proceeding was about?
right, but that necessitates the client attorney.
Didn't she probably draft the motion?
Yes, but she wouldn't have been able to do so without hearing statements from her client. And so what we're talking about here is things that she was instructed to do or requested to do or otherwise did because of the attorney-client relationship, which would require client describing to you, here's what I want you to do, and then that becomes a motion to relocate. So the lawyer would need to learn from client
You're
that
stretching here. The attorney can file a motion to relocate, and that is not hearsay. And to relocate to Colorado Springs, she can know what she filed. Why don't you find her remarks to what she did? If there's a reason to go further, we'll see.
Yes, Your Honor. So, Ms. Harrison, did you file a motion to relocate on behalf of Ms. Hall to Colorado Springs?
yes, I did.
What did that motion ask the court to do?
It asked the court for,
if I may, objection. This requires description of what client wanted. Lawyers don't just file motions to relocate without the hearsay from client that says, this is why I want you to file it. That's exactly where the prosecution is going with.
You're overruled. She's saying what she did. We all understand that's probably what Ms. Hall wanted. This is not hearsay. This is what she did. This is what the motion stated. You're overruled. Go ahead.
Thank you, Your Honor. Ms. Harrison, what did the motion ask the court to do?
motion requested Ms. Hall be granted permission to relocate with the minor child, Dylan, to Colorado Springs.
Did this bring about a need for a new, more formal custody agreement?
Yes, it did.
So even though Ms. Hall, as you described it, had custody basically informally, did you file motions and were motions filed in terms of formal custody at that point?
Yes, we filed the motion to relocate and the motion for Ms. Redwine to be the primary custodial parent with visitation to Ms. Hall, to have primary custodial parenting rights and for Mr. Redwine to have reasonable visitation.
Did you meet with Dylan Redwine as part of that process?
Yes, I did.
And before I talk about that custody hearing, let me talk about your relationship over the years. Did you get to know Dylan?
Yes, I did.
How did you get to know Dylan?
After Ms. Hall and I thought her case was over, because I don't mix friendship in my attorney-client relationship. When we thought that was over, we decided it was okay for us to develop a friendship. Through that friendship, I had the opportunity to meet Dylan, play board games with him, watched movies with him, hung out with him.
When did you become, when did it segue from the more professional relationship over to a personal friendship?
After the decree was issued in 2009, Ms. Hall and I started a friendship, but it was some time later before I actually went over to her house and met Dylan on a personal level.
Did Dylan talk to you individually at times?
Yeah, we talked a lot over the years, but never talked about Mr. Redwine.
And then after you developed this personal relationship, then it sounds like in 2012, more court litigation came up.
Yes, at which time Dylan specifically requested to speak with me about his testimony to Judge Dickinson.
Okay. And did Dylan tell you his thoughts on where he wanted to live?
Yes, he did.
And what did he tell you?
He wanted to live with his mother.
Did he tell you, about, well, did you watch the relationship firsthand between Dylan and Mark Redwine over the years at all?
I never saw Mark or Mr. Redwine over the years. I do know that, over the years, the relationship deteriorated because it was clear that Dylan didn't want to go visit with his father, just based on things that I had seen.
Did he ever voice concerns to you about, going to see his father closer to the time of the Thanksgiving visit?
Yes, when we met before the, September hearing on the motion to relocate.
What were Dylan's concerns?
He was not comfortable around his father. He disclosed to me that he had seen the pictures that, creeped him out and made him feel very uncomfortable.
Then, when the hearing occurred, how does that hearing work? For example, does Dylan get input?
Because of his age, we filed a motion for him to be able to testify or to be interviewed by the judge in chambers. That request was granted. So during the hearing, Dylan was taken into chambers by Judge Dickinson and was interviewed in private by Judge Dickinson.
Okay. And then, is that the purpose of that interview, to get Dylan's input on where he wants to live?
Yes, sir.
And then also, you mentioned the pictures. Are those I'll refer to them as compromising personal photographs, as those are the pictures?
Yes, sir.
Did he describe them in detail to you, however?
No, he didn't.
Okay, what did he tell you about them, or them upsetting him? What did he?
He told me they were creepy pictures, and he told me he was creeped out by it, and he didn't want to visit with his father. I personally have never seen the pictures, so, but I'd heard about them, so I knew what they were.
And then going into going into the hearing itself, what did the court ultimately decide after hearing from Dylan and hearing from the parties with regard to custody?
The court granted Ms. Hall's, motion to relocate, meaning that Dylan would be residing with her primarily up in Colorado Springs, and Mr. Redwine was granted visitation rights.
Was there a specific visit that he was granted at the time of that hearing?
I believe it was a Thanksgiving visit.
And that was a part of that same order that had given custody primarily to Ms. Hall?
Yes, sir.
Was that in fact a court order?
Yes, it was.
Now, I want to talk specifically about that visit. Did you talk with Dylan after the hearing about whether he wanted to go on that visit to see his father for Thanksgiving?
I do recall speaking to Ms. Hall. I believe Dylan was in the background, but I did not speak to Dylan directly.
Were you asked legal advice?
Yes, I was.
Were you asked about whether Dylan did or did not have to go on that trip?
Yes, I was.
What were you asked?
I was asked if there was,
Objection, hearsay.
Wasn't this testified to yesterday? And isn't this being asked so she can explain what the advice was? I mean, why is that hearsay? So, you ask a question, is that for the truth of the matter asserted? I don't think it is.
This out of the court statement, were you asked this question?
Out of court statement offered for the truth of the matter asserted. This is the question, were you asked? So, it's a question being asked, so what's being asserted? So why is it hearsay?
I don't remember what the question being asked is, but the premise of the question is the truth of the matter being asserted, and that makes the question and the contents and subject matter of it hearsay.
No, it doesn't. Have a seat.
Ms. Harrison, what were you asked about that trip?
I was asked if there was any options to putting Dylan on the plane.
Who asked you?
Ms. Hall.
Was that on behalf of Ms. Hall and Dylan Redwine asking you legal advice?
That
Yes.
could probably be, part of that could be hearsay. So just go ahead and ask your next question.
Okay. So, based on the question you were asked, did you have to give Ms. Hall a response as to whether or not Dylan had to get on that airplane?
I did give her legal advice.
What did you tell her? Take your time, ma'am, and there are tissues to your left as well.
I told her that she had to put Dylan on the plane or she would be charged with contempt of court.
Are you okay to proceed, or do you need a second? Ms. Harrison, how did you find out that Dylan Redwine was missing?
I received a phone call from Elaine.
When did you receive that phone call?
The day after Dylan arrived in Durango.
And what did you, I don't need the specifics of what you were told, but you were generally informed, that Dylan was missing?
Yes, I was.
When Ms. Hall called you, was that a call about anything related to a court case, or was that a personal call, about Dylan?
She called me as a friend.
What did she call you about specifically?
She needed to inform me as to what was going on, and she needed to know if she had a place to stay in Durango.
And did she have a place to stay in Durango?
Yes, she did.
With whom?
Me?
What did you do after you received that phone call?
If I'm not mistaken, I called his attorney.
And why did you do that?
Most likely because I couldn't call Mark, and I wanted to know if she knew of any information about where Dylan was.
At that point in time, was the goal of everyone to find information about where Dylan was?
Objection as to how she would know everybody's goal.
I'm gonna sustain that.
Understood, Your Honor. Ms. Harrison, based on the people that you were interacting with, was it the goal of the people you were interacting with to
Yes,
find Dylan?
it was.
What did Elaine Hall do?
Pardon me?
What did Elaine Hall do after she had notified you that Dylan was missing?
I instructed her to contact the Plata County Sheriff's Office and report Dylan as a missing person. She did.
And then did she travel?
Yeah, she immediately got in the car and drove to Durango.
Did you see her when she arrived?
Yes, I did.
And did she stay with you?
Yes, she did.
And who else arrived with her?
I believe at that time it was, Mr. Hall.
Corey Redwine there as well?
Yeah, he probably came that same night.
Did you know all of them?
Yes, I did.
And were they all welcome to stay with you?
Yes, they were, and they did.
What was it like in the days that followed in terms of your involvement in trying to find Dylan?
Every day I watched everybody that was staying at my house leave to go on searches, search for Dylan in Vallecito and everywhere else that they thought he might be.
Did you stay involved over the course of the months that followed?
I did.
How did you hear about Dylan's death?
I can't recall who told me that they found remains. It was most likely Elaine.
Were you still in the area at the time?
I was.
Do you see Mark Redwine in the courtroom here today?
Yes, I do.
Where is he sitting, and what's something that he's wearing for the record?
He is sitting all the way to my left, and he is wearing a gray suit with a white shirt and glasses.
I would ask that the record reflect the witnesses indicating the defendant.
It can.
Thank you, ma'am.
Thank you.
So, yeah, just hold Hold on just a second. Go ahead, Ian. I'm watching. A little more, a little more. Just a touch more, a little more. Good. Thank you. We need a better picture of you.
Please don't.
Whenever you're ready, Mr. Moran.
Thank you, Your Honor. Thank you. There's a lot of materials.
I have trouble finding them too, I understand.
Appreciate the moment to look through it. Thank you. Good morning.
Good morning.
Just to clarify a couple of things you were discussing on direct, you recommended that Ms. Hall, now Ms. Hatfield, call law enforcement when she called you on November 19th.
Yes, I did.
You didn't call the sheriff's office, right?
I don't believe so. I may have.
And your call was to the lawyer, right?
Correct.
And you mentioned that you do not carry on friendships with clients, correct?
That is my policy.
And Ms. Elaine Hall is your friend,
Yes, she is.
and she is your client.
Yes, she is.
You're currently attorney of record, right?
Yes, I am.
And you guys are close enough that you travel together, is that fair?
I'm not sure when you're speaking about.
A trip to South Dakota, Mount Rushmore.
Yes, sir, we recently did take a trip there.
May I approach?
You may.
Objection if, this exhibit's gonna be admitted, Your Honor.
Okay. And what number is that, Mr. Moran?
I'm gonna hold off on that for a second. I think that my ability to get that up on the screen is gonna take a moment, so
All right.
if I could get back there. In order to provide the information that you're giving today and that you've given on other occasions in this case, Ms. Hall had to waive attorney-client privilege, right?
Yes, I believe so.
And you would agree as an attorney and former judge for the Municipal Court of Ignacio that violating attorney-client privilege has very serious consequences for a lawyer?
Not if it's been waived by the client.
Sure. But in the absence of that waiver, it's extremely serious, right?
Yes, it is.
Presumptive disbarment.
Yes, it is.
It's an extremely important responsibility for a lawyer.
Yes, it is.
And the idea behind it is that information provided between client and attorney is confidential so that you can be provided the unvarnished truth.
Correct.
And you would agree with the principle underlying this rule for lawyers that a lawyer's responsibility to act as counsel is best served when clients speak freely and candidly with their attorney, right?
Yes, I do.
You encourage honest sharing with your clients, agreed?
Yes.
Doing so allows you to provide state-of-the-art representation.
Yes.
Advice you give is based on info that clients provide you, right?
Yes.
And in this case, the information provided to you by Ms. Hall was that she did not think Mr. Redwine would ever hurt Dylan Redwine, correct?
Correct.
So your entry of appearance in the domestic relations case, divorce case, was in 2008?
Correct.
And that was the divorce of Elaine and Mark Redwine, obviously,
Correct.
and you were working for another lawyer's law firm at the time.
I was working for Greenberg, Herringer, and Ward.
How much were clients charged per hour?
I don't recall what the prices were back then.
More than $100 an hour?
Yes, sir.
More than $200 an hour?
No, sir.
You continued working Ms. Redwine's case for, since at least 2015, right?
Correct.
And also another important responsibility of counsel is to seek expeditious resolution of matters to include divorces, correct?
Objection of relevance?
I'm not sure where you're going with this, Mr. Moran.
Established bias.
Well, we'll see. Go ahead.
You have a responsibility as counsel in the divorce matter to seek expeditious resolution of the Redwine divorce matter, correct?
As quickly as I can, absolutely.
You would agree that the divorce involved multiple lawyers and went on for more than 10 years.
I believe Mr. Redwine had multiple attorneys. Ms. Hall remained with me, and yes, litigation went on for a number of years.
And there was a lawyer that Ms. Ms. Hall had engaged prior to your representation, right?
For the legal separation, yes.
You spoke to Dylan before he met with Judge Dickinson, right?
Correct.
Do you recall the placard or instruction, description that was on podiums in Judge Dickinson's courtroom? Your Honor, as Your Honor will recall, Judge Dickinson...
You know, I don't remember that. Go ahead.
This may be something that I could seek judicial notice of. In his courtroom, there were things on the podium saying that the manner of his speech was not related to his reason and cognitive ability, that he had an issue that...
All right. I can, do you need me to instruct the jury on that or not?
That would be great.
I'm sorry, Judge.
You don't know what we're talking about, I know.
No, and that
Okay.
may make it inappropriate for it to be admitted. But I have no idea what counsel's referring to.
I know you don't, because you weren't here.
Seems irrelevant.
Well, I'm gonna instruct the jury that, Judge Dickinson, shortly before he retired, developed the condition, and I think I remember the correct name for it, but I don't want to say it because I'm not sure that's correct. And it basically made it appear as though, well, it made him slur his words, it made him appear as if he was intoxicated, which he was not. He had full control of his faculties, he just had a difficult time enunciating his words, and it progressively got worse. And it eventually caused him to retire. So that's what you're referring to, correct, Mr. Moran?
Yes, Your Honor, thank you. So you spoke to Dylan before he met with Judge Dickinson, right?
Yes, I did.
And as is your practice, as is required of a licensed attorney, you would have encouraged him to be honest with the judge, correct?
I did instruct him to be honest with the judge.
You told Dylan what to expect with his meeting with the judge, correct?
I described the procedures, tried to reassure him that Judge Dickinson was another human being that he could feel comfortable speaking to.
And you described to Dylan what questions the judge might ask, right?
No, I did not.
You didn't prepare him for the topic of discussion that would be in chambers of Judge Dickinson.
No, I did not. The topic of discussion was entirely up to Dylan.
Okay. But you did prepare him to go back there and encouraged him to be honest.
I encouraged him to be honest in whatever he needed to tell the judge to make sure that the judge understood how he felt.
Okay. So that would have been part of what you were describing for Dylan, and he would have been aware that it was a discussion about where he preferred to live, correct?
Dylan was old enough to know what we were going to court for. It was his request to testify or to speak to the judge. So I didn't have to tell Dylan what we were going to court for.
Do you recall that one issue of contention in the divorce was damage to the property on the Windmill Street, at the Windmill Street address?
Yes, I do.
And you recall that Mr. Redwine, after the property became his, had to make repairs to the property so that it could be rented or sold?
Objection of relevance.
So what's the relevance to that?
This issue has come up with other witnesses, what was going on at the Windmill House. This is the witness who would...
What's the relevance to the damage? I don't remember damage at the Windmill House. What's the relevance to that?
The beer bottles that were discussed earlier today in the text messages the prosecution introduced.
What's that got to do with damages at the windmill house?
It informs what was going on in the windmill house and how it was subject to litigation.
I'm going to sustain the objection.
Moving on. Do you recall that one of the issues that was in contention was claims by Mr. Redwine that Elaine Hall was alienating him from Dylan?
I believe that was one of Mr. Redwine's claims, yes.
And you advised Elaine Hall to get Dylan Redwine a cell phone, right?
I don't recall.
Would it refresh your recollection to take a look at the transcript?
Sure.
I'm going to ask the council to provide a little more context to that question.
In terms of deciding what relevance is? Or
Relevance, when, what context?
This would have been a hearing that occurred on September 21st, 2012. The relevance is that it gives more information about the alienation going on between the child and the parent. The relevance also includes that it informs around the issue related to your honors, limiting instruction involving the photographs. Any further record I would ask to make it to bench.
Well, why don't you show her the document, and we'll see where we go.
Permission to approach.
Yes.
What document is this, council?
Page 3,682 of discovery. Beg your pardon, it's 3,667. line 17. Beg your pardon, my site source is incorrect on that. I'll have to double back on that. Fair to say that there was litigation around Mr. Redwine's objection to Dylan being moved to Colorado Springs.
Yeah, yes, Mr. Redwine, objected to the request to relocate.
Ms. Harrison, you would agree that it's important for lawyers to keep records.
It is.
Failing to maintain an appropriate record-keeping system is a violation of the rules of professional conduct that can result in the loss of your law license.
Yes, in general, yes.
It's also important to the billing process to document client meetings.
Yes.
And the lawyer has a professional obligation to document witness interviews.
Question of relevance, Your Honor.
May I approach?
Well, do you have a response to the relevance objection?
I do. The relevance here is that there is no note that we've ever been provided with respect to descriptions of the pictures at issue by this lawyer who's noted that she was aware of them and had discussed it, and if that's the case, that's never been provided to us, and I don't believe that there's any record of it, at least for this case.
She's not law enforcement.
She is a party that is regularly reported with respect to this matter.
She's not law enforcement, so therefore she's under no duty to provide anything to you. So I'm gonna sustain the objection. I mean, I would hope that, the prosecution is giving you everything they have.
We have, Your Honor.
And I don't know that they asked for everything. So what do you want to approach now again?
On that issue, this is just something that I think is wrought with possibilities that are problematic to discuss.
I really don't see where you're going with this, Mr. Moran. You need to move on.
You never included mention of the embarrassing pictures in a pleading, did you?
No, I do not think that the,
That's my question. Thank you. You did have an opportunity to review the recorded interaction between Judge Dickinson and Dylan, correct?
no, I did not.
That would have been available to you as attorney of record, correct?
Correct. However,
That's as much as I'm meaning to ask on that issue. In addition to being friends with Elaine Hall, you had Corey Redwine staying at your house, house sitting and dog sitting, right?
Mr. Corey Redwine stayed at my home during Dylan's disappearance while they were searching for his remains. And if I'm not mistaken, they brought their dog. So did Ms. Hall.
Ms. Harrison, have you watched the surveillance footage of Dylan Redwine in Walmart on November 18th, 2012?
No, I have not seen the surveillance video. I saw the pictures that were posted in the newspaper.
And you stated at a deposition that there were marks on Dylan's arms on the images from Walmart, right?
Didn't the witness just state she'd not observed it?
Right, and now he's trying to impeach her with something different that she said, so I think it's okay.
I don't know that I was ever deposed.
You recall that you were participating as the lawyer in depositions where you asked if Mr. Redwine could see the marks on Dylan's arms.
Asking a question is not evidence and it's not testimony, therefore I believe, that you cannot ask this question, can you?
The rules of professional conduct require that you have a good faith basis to ask questions. And fishing like that, I
Right,
think,
but
would be
we
a
don't know
problem.
what was going on in that deposition. We don't know what the issues were. I'm not gonna let you ask him.
Have you ever seen scratches and otherwise marks on Dylan Redwine's arm in footage from around the time of his disappearance?
Again, I didn't watch the footage.
Following July 23rd, 2009 permanent orders hearing, Elaine was ordered to pay Mr. Redwine $72,514, right?
Objection of relevance.
Any relevance to this?
It goes the bias of Ms. Hall and her close friend here.
All right. You can answer the question.
I don't recall the amount. I believe what you're speaking about is permanent orders that were issued following our permanent orders hearing in July of 2009. I think that's what you're asking about. Yes, she was ordered to pay an equalization payment, I believe.
Would it refresh your recollection what that equalization payment is? If I showed you a copy of that permanent order?
Sure.
I'll refer here to line 34, it's page 23,241 of discovery. Commissioner Reproach.
Yes.
Correct.
Does that refresh your recollection as to amount?
Yes.
The original amount was $72,514, correct?
Correct.
Payable by Elaine Hall to Mark Redwine, right?
Correct.
After an appraisal on that house and some more litigation, that payment was reduced, right?
Correct.
To your knowledge, have those payments ever been satisfied?
Objection or relevance, Judge?
It goes to
Well,
bias in a really obvious way.
Hold on a second. I interrupt you. Go ahead and, I'm sorry. Go ahead and.
If I might just say first that, of course, it's an unpleasant thing to inquire after, but it's relevant to the bias. If someone is owed money, then the bias that could involve in that is obvious. It goes to the instruction on credibility that the jury was provided with respect to what the outcome of a case could mean to participants. The relevance here is obvious in my mind.
Mr. Johnson?
Your Honor, if the argument is that there's a bias over $7,000 when Ms. Hall's son is dead, I renew my relevance objection.
You know, it's for the jury to weigh whether or not that is sufficient to cause bias or not. It's not for me or for you to decide. So you can answer the question.
There was litigation back and forth over the marital estate.
Ma'am, hold on. The question is different. The question is, was that payment ever satisfied to your knowledge?
I don't think that I can answer that question the way you're asking it.
So the answer is no, it was not paid.
No, that's not what she said. You can answer, she's sworn to tell the truth, and if she needs to tell you more than you want to hear during the answer, she's entitled to. So why don't you answer his question?
We litigated back and forth over the value of the marital estate and how the equalization was going to be paid. The end result is that Mr. Redwine was awarded the windmill home, and that was, I believe, the end of the property division once and for all.
At this point, I'm missing the person who's got this image to put on on the screen, so I'll just, by stipulation, ask that it be admitted. It's Defendant's Exhibit 1163, an image of counsel.
I think you already stipulated to that, correct?
Yes, Your Honor. No objection.
Okay, that will be at some point. You have copies for the jury, though, correct? And the original press?
If not at this exact moment, we will.
It'll be admitted. You'll get to see that at some point. So. Anything else then, Mr. Moran?
No, thank you.
Any redirect?
Just very briefly, Your Honor. So, Ms. Harrison, you were asked a question about why you didn't reference the photos in the pleading, and you started to answer it, but you were stopped. Would you like to answer it?
Yes, I would.
Please answer that question.
As an attorney, I did not see the relevance of those photos. They would not indicate in and of themselves that Mr. Redwine was a bad parent.
And did you mentioned that you knew Dylan was going in there and you didn't tell him what to say, but you told him to be honest, right?
Correct. I tell all my clients, tell the truth. This is your story. It's not mine. I tell you what to say. You're not going to be able to tell your story truthfully.
So you let Dylan go and tell the judge what he wanted to tell the judge?
Yes, I did.
Did the defendant know that Dylan was going to talk to the judge about who he wanted to live with?
I don't know what Mr. Redwine thought, but Mr. Redwine knew that Dylan was being interviewed by the judge.
Let me ask a different question. Did all the parties in the case know that the purpose of the interview with Judge Dickinson was so that Dylan could say where he wanted to live?
Judge Dickinson would be assessing, and taking into consideration Dylan's wishes.
And you talked a little bit, there was a lot of talk about property and things like that. But let me just orient you to a timeline. By the time of this custody hearing, had property disputes all been resolved?
I believe the property disputes were resolved. I think we had one remaining court issue as to reimbursing Mr. Redwine for the alleged damage at the windmill house.
Sure. The litigation over who got what property, had that been proceeding from 2009 up to 2012?
Yes.
In that period of time where there was litigation over the property, did Mr. Redwine ever make a motion for custody over that period of time?
No.
And then he got the windmill home, and there was the motion to relocate. All the properties finalized. Then what did we do?
When there was nothing else to litigate over property-wise, then Mr. Redwine all of a sudden wanted to be the primary custodial parent and used the fact that Ms. Hall had to travel for work, wherein Dylan had to go with her and therefore miss school, as a basis to award him primary custodial care for Dylan.
And he did this after years of not bothering to visit.
Correct.
Objection leading.
All right.
I'll withdraw the question.
Answer's already out.
Objection.
Anything else?
No, Your Honor. Thank you.
Any questions from the jury? Can this witness be excused?
Yes, Your Honor.
Mr. Moran? Thank you, Ms. Harrison. Thanks for coming back. Next witness?
Thank you, Your Honor. The people called Kathy Berry.
Ms. Berry? I'm sorry, I wasn't watching. I was thinking about something else. I wasn't watching. Up to the witness, stand up here, please. And if I can have you raise your right hand? No, over here.
Up
The
here?
light on TV, yeah. Raise your right hand.
I don't know what I'm doing, I'm sorry.
That's all right. Do you solemnly swear or affirm under penalty of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Have a seat. Speak into this microphone.
Good morning, Ms. Berry.
Good morning.
Could you please start by introducing yourself by your full name to the jury?
Yes, my name is Kathy Louise Berry,
And could you please spell your last name for the court reporter?
Barry. It is Kathy, Kathi.
And Ms. Berry, where are you from?
Where am I from? I was born in Utah, raised in Wyoming, and have lived in Colorado since I was, 20, 18, something like that. So mostly Denver.
Okay. And have you always lived in Denver, that part of Colorado?
Yes.
Is that Evergreen? Is that considered Denver?
Evergreen is 30 miles west of Denver in the foothills.
Okay.
And yes, I've lived there for 25 years.
What do you do for work?
I'm a mortgage broker.
Okay. Do you know Elaine Hall?
Yes.
How do you know her?
I met Elaine on one of the searches for Dylan.
How did you become involved in the searches for Dylan?
I saw Elaine's picture come across my news feed on Facebook one day, and she was standing on a dam, and she just looked really sad, and so I just wanted to help her.
And when you were trying to help her, did you get involved at the stage where Dylan was a missing child, or did you get involved after his remains had been found?
Missing.
So why did you get involved? What was the purpose?
Why did I get, because I wanted to help find, I just wanted to help find him.
And at that point, was it known what had happened to him?
No.
Did you also know someone named Denise Hess?
Yes,
She a friend of yours?
she was.
How did you meet her?
I met Denise Hess, on the night I arrived, here to do the search the next day. She helped me. I reached out to the, Find Missing Dylan Redwine page, and she messaged me and helped me, find a place to stay. And that's how I met Denise Hess.
And then did you become friends with her after that in the context of searching for Dylan?
Yes,
Is she still alive or is she deceased now?
she's deceased.
How did she pass?
She passed away of colon cancer.
Do you know Mark Redwine?
No,
Do you know what he looks like?
yes,
Is he here in this courtroom?
he is.
Can you please indicate where he's sitting and something that he's wearing for the record?
He's sitting right there, and he's wearing a gray jacket.
Does the record reflect that the witness is indicating the defendant?
Well, there's a couple gray jackets here.
He's got glasses on, he's looking at me.
All right, I think that's close enough.
Thank you. So you don't know him personally, correct?
I do not.
Have you had an incident where you met him before, however?
Yes. Sort of, I guess.
Is
Okay.
this the incident that I need to do the limiting instruction?
Yes, Your Honor, and this would be a good time. Thank you.
Ow.
Okay. Ladies and gentlemen, the evidence you're about to hear about is admitted for a limited purpose. The evidence is not being admitted to prove the defendant had a bad moral character, and the jury cannot use this evidence for that purpose. This evidence is being admitted in an attempt for the prosecution to prove that the defendant became violently enraged when confronted by others concerning his sexual preferences. They can be used by the jury for these purposes and no other.
Thank you, Your Honor. And as we approach that incident, Ms. Berry, so how long were you involved in the search for Dylan while he was still a missing child?
Well, I came for the search. I came for the gathering in February of 2013. At this point, we didn't really know for sure what had happened. And then up until they found his remains, I guess, he was a missing person.
Okay. So from February to roughly late June?
Correct.
And were you interacting with Denise Hess, Elaine Hall, and that group of people who are interested in finding Dylan?
Mostly Denise Hess.
Okay. And then what happened? Was there an instance when Dylan's remains were found and a lot of people were very upset?
Yes.
Can you just explain how you became aware that Dylan's remains were found?
I was here in Durango, or I was in Vallecito at the time, and I remember somebody saying that they had found a shoe or something. I mean, we knew at that point that they had, I'm trying to think if this is, it's hard to remember the exact dates, but they had confirmed that Dylan's remains were found that day. That was the day, and that was the day that Elaine received a text message from Mark that said that he hoped her and her colon cancer riddled BFF died, and that she died too. That's what he said.
Objections out of here, sir.
You need to object just a little sooner before it gets out. Do you have a response to the hearsay objection?
I mean, the answer is, Judge, that it informed what they did next, and that's the reason it's relevant.
So the objection is, I didn't want to give you a reason. That's your job, so overruled.
So that text message you referenced, did that upset people?
That's why we went there, yes.
Were people also upset generally? Like, was this
Yeah.
a difficult time?
It was probably one of the worst days, I think, ever.
So how close in time was this to finding the remains, that this whole interaction we're talking about?
I think it was the same. I mean, I know they announced the remains
that day that for sure they were Dylan, but that was not the day they found them. I believe it was earlier than that.
So everyone was upset about the remains as well? Both topics, I guess
Yes,
is my question.
absolutely. Mhm.
So then did Denise Hess, and you decide to go somewhere?
Denise wanted to confront Mark about the text message. She wanted to go over there. She had been talking about it for a couple of hours. She was enraged and wanted to go confront Mark about the text.
Okay.
And so everybody pretty much calmed her down. She wasn't going to go, but then she was going.
Okay. Was there also, and we'll get to this when you got there, but was there also discussions leading up just about the idea of confronting the defendant about Dylan as well?
I don't recall that, no. I mean, it was more just, she was really angry about she knew Mark and she was upset about the text.
Understood. So what did you do at that point?
I told her that I would drive her over there if she wouldn't go alone, because she was going to go alone.
Did you in fact drive over there?
I did.
And where was over there?
Around from where I was pretty close to the lake over on Mushroom Lane. And so we just basically drove down the road and took a right and drove down the road, and we passed and then a dead end, so we flipped back and came back. And that's when he was standing there.
Is this the Mark Redwine's home in Vallecito at 2343 County Road 500 up north of the lake?
Yes.
When you drove over there and you flipped around, then where'd you go?
We were driving back, and Mark was standing at the door. I think he was standing there in his underwear, and he asked, Kat said, stop. So I stopped.
Kat.
Oh, I'm sorry, Denise Hess. I call her Kat. So we stopped, and do you want me to continue about?
So where did you stop?
We stopped right in front of his house on the road.
Did you ever go on his property?
No,
Did you ever get out of the vehicle?
no,
And when you stopped out front, he was already at the doorway?
yeah.
What did you do then?
I was pretty freaked out. I was just kind of sitting there. Kat was doing most of the talking. Denise was doing most of the talking to Mark. They were yelling back and forth.
Okay. What was she yelling at him about?
It started out, she said, hey, Mark, why don't you come outside? And he said, fuck you, why don't you come over here? And then she said, I'm not coming on your property. And he laughed at her and said, come on. And so he called her the C word. I think she called him a few names. They interacted for a couple minutes.
Did it remain verbal?
Yes.
At some point, did she say something about not letting him forget what he'd done to Dylan?
She did.
And then, go ahead.
She did. She said, because he had said something to her about dying of cancer, something about the last breath, and he was laughing. And she said, yeah, well, it will be my last breath, and I will make you pay for what you did to Dylan, or I can't remember, but it was in reference to that.
So in even saying what he did to Dylan, did it stay verbal all that time? At some point, did you speak up and yell something at him too?
I did. So I was pretty quiet. Didn't actually through the whole thing. I said nothing, and I was tapping her like, let's go. I was kind of afraid of him anyway, but they kept talking, and when he said something about that he would dance or something when she was dead, and he was laughing. I remember him laughing.
What did you say to him?
I'm telling you, I literally lost my mind. I flew over the seat. I was almost on top of Denise. I took my seatbelt off first. I flew over the seat. I had my head out the window, and I called him a eating motherfucking piece of shit eating asshole. I really, it went on and on. I think I probably said it 10 times.
Let me stop you. Did you specifically, you just said shit eating?
Yes,
Were you specifically referring to photographs yelling at him, calling him a shit eater?
yes.
Did his response change from a verbal argument where he was laughing and cursing
Yes,
to something different at that point in time?
yes.
Please explain that to the jury.
So he had come out the door at one point. Kat was telling him to come out. He was telling her to come on his property. And he was standing kind of by the driveway, and that's when, you know, he was kind of coming towards my car. And I was screaming, and then all of a sudden he picked up this log off this, it was like a stove or something in the yard. I can't remember what it was, like a oven or something. And he picked up that log, and he fucking like this. And all I remember was, I don't know if you've ever seen the cartoon where the eyes bulge out and all you can see is the white of the eyes, but that's all I saw. And it scared the shit out of me. And I just said, let's go. And Kat she was saying something else. And then I said, eat more shit. And I hit the gas and I went.
Did he come towards the vehicle?
He stopped at one point, but he was pretty damn close.
So he had been, you described, at a location at the doorway,
Yes.
and then a location at the
It was,
wood stove.
it was closer up by the driveway and yeah, he was at the edge of that driveway.
Came out to the,
Yes, but he didn't leave his property.
and then why did you speed off?
Well, I didn't want him to hit my car with the log or Cat.
Were you scared that might happen?
I was absolutely convinced it was gonna happen if I didn't go. Yeah,
That he was either going to hit the car or hit Kat because
Yeah.
she was closer, she was on that passenger side?
yes.
Thank you, Ms. Berry.
You're welcome.
So, Ms. Berry, I don't mind you using cuss words when you're describing what happened, if those were the words that were used, but when, in terms of what happened at that house, but when you're describing your reactions, please maintain
Okay,
a little decorum.
absolutely.
All right, Mr. Moran?
Your Honor, I know it's a few minutes early, but I have something I'd have Ms. Berry review that may save time if we do it now. Of course, whatever Your Honor's pleasure.
Well, I don't care. I mean, whatever you think is the fastest way to get through it is what I want you to do.
I think that it would make sense to have her review it over the lunch break, and then we can do the chat.
Okay, and what are you asking her to review?
A transcript of her one and only description of this interaction she's just described.
All right. Do you have any problem doing that, Ms. Berry?
No?
Okay. What we'll do then is we'll take our lunch break. Remember my admonitions about not talking to anybody. Don't let anybody talk to you. Don't do any research on this case. We will start up again then at 1:15. So thank you very much. Everybody rise for the jury. Rise for the jury, please, instead of talking in the courtroom when we're on the record.